Hello and welcome to Let's Talk HR with Dr. Deneen, the talk show that spotlights HR professionals and talks about all things HR. Workplace internal investigations have taken center stage in today's climate. Oftentimes, HR plays a significant role in the investigation process. As HR professionals or business leaders, you should be well versed on the topic, know the mechanics of how workplace internal investigations work, and know what your obligation is with regard to them. To help me discuss what you should know is attorney Jeff Weintraub, Senior Counsel, Fisher & Phillips, LLP. Thank you for coming on the show.
Thank you, Dr. Lester, for having me.
Once again, right?
Once again.
I think he's becoming the resident attorney for this talk show.
A two-timer.
Two-timer.
Yeah. Wait, that didn't sound right.
No worries. But I'm so glad that you're here. So
Thank you.
Last time we were here, we not only found out that you were a legendary attorney and a musician with a band, but this time you're also a skier, is that right?
Yeah, we just came back yesterday afternoon, in fact, from a ski trip to Snowmass in Colorado, where we got snowed in and all flights were canceled and it was a crazy mess. But yeah, we had a great time there.
Okay.
And I do have pictures from my ski trip, primarily the drinks and food that we had to eat during the trip.
Well, I'm sure that was loads of fun. So let's dive right in.
Okay.
So Jeff, why investigate workplace internal investigations? Why should we investigate those?
Well, gosh, that's almost a philosophical question. I guess the first and main reason, Dr. Lester, would be the simple fact that the statutes require us to investigate, because the whole purpose of all these employment statutes, when you really kind of get down and look at the legislative history, is to go into the workplace even proactively and ferret out discrimination, harassment, retaliation, and eliminate it. And you're not going to find out what it is until you investigate.
Right.
So that's primarily the reason. I would say probably the second reason is because the whole concept of investigation has, in the last, 20 years, become really your primary defense in many cases in an employment discrimination case if you're a company. And I suppose the reason for that is because, from what I've seen, let's just take sexual harassment, which is the one everyone talks about the most.
All right.
Having had hundreds of sexual harassment lawsuits, cases, charges, so forth, out of all those, I've only seen 5 where nothing happened, where the allegations were completely fabricated.
Oh, wow.
Which tells me that when I'm faced with a sexual harassment situation, that probably something happened.
Something happened, so we have to get down to the...
You got to get down to that. But the bottom line is, on a lot of discrimination lawsuits, companies and supervisors can say, hey, I didn't do it. You discriminated on the basis of age, didn't you? No, I did not. But you can't do that with sexual harassment cases, because something probably did happen. That supervisor probably did something. Not every case, I don't want to get too cynical, but something probably happened. That means you can't defend these cases by the old standard of saying, we didn't do it if you're the company.
Okay.
All you can say is that when we got the complaint,
yes,
we investigated.
Yes.
And we did prompt remedial relief if it was called for. And by doing that, the investigation itself has become the company's defense to these charges and these harassment cases. So that's really the second reason. Third reason, if you're on a jury, have you ever been on a jury, Dr.
I
Lester?
have.
Well, I have too. They never pick me because they don't want lawyers on their juries back there. But juries expect companies to do a good faith, thorough investigation. Right. And if the company doesn't do so, they're going to be ticked at that company because they put themselves in the shoes of the plaintiff and they say, hey, would I want there to be an investigation by the company in good faith of my claims if I had a claim? And they would.
And they would. Yeah, and
Those
so
are, I
that's
think,
why
the
we do it.
reasons.
Yeah, those are the reasons. So it gives employers the opportunity to set a, I guess, course of action, right? That's what you want to show, that you're showing a course of actions, that you took initiative, that you took action with regard to the complaint, right?
If the company knows, it's got to do something.
Yeah.
It's got to take action.
You got to take action. So you talked a little bit about the statutes, and you talked about the statutes for employment law. So what are some of the laws, or which laws require that you do workplace investigations?
All of them.
All of them. All of the laws, okay?
The bottom line is you have to investigate under all these. We always talk about Title VII because
Yes.
that's the
Yes.
biggie.
Yes.
But if you don't investigate, you're not going to know what happens. And I've had lawsuits, cases where my client has been sued for discrimination or harassment, where when I came to the case at the lawsuit stage, they had never investigated initially.
Oh my goodness.
That's like strike one, strike two, it's almost strike three. Because if you didn't investigate, you couldn't do anything to prevent the problem or to solve the problem
Yes.
afterwards without investigation.
Okay.
So everything from Title VII to OSHA and TOSHA, the Americans with Disabilities Act, the Age Discrimination and Employment Act, the Family Medical Leave Act, on and on and on and on. The Tennessee Poor Performance Protection Statute, which bars employers from firing an employee just because you can't do the job.
Whoa.
Okay, wait a second. I'm
You
just
got it.
kidding. There is no Tennessee Poor Performance Protection Statute. I just wanted to see if y'all out there were listening.
Hey, and if HR professionals know what some of the new developments are, but hey, you caught us by surprise. It made me stop. Wait a minute, what is that? But anyway, so those are the things that are so important to know. So let's talk about the workplace internal investigation steps. What are the steps to a good workplace investigation?
Well, I think you start, obviously you're going to start by meeting with the complainant, and you're going to want to, advise the complainant that they're free to complain, that there will be no retaliation against them for any complaint they might make. And then you are going to commence your investigation if it's appropriate for the particular circumstance. And we always say, never terminate anybody on the spot. And, there are times when you have to get someone who's angry and fighting, you have to get them out of there, but you just suspend them.
Yes.
And then it gives you a chance to do your investigation. So you're going to plan out your investigation steps at the front end, figure out what you're going to want to do first and second and so forth. So you're going to want to, meet with that complainant, find out what all the issues and the facts are. Then you want to collect all the documents that might be relevant in the personnel files. And you're going to want to figure out who to talk to. The complainant's going to give you a couple names. You can talk to this person as a witness and that person as a witness. Always want to remember these witnesses in these protected group discrimination and harassment cases, the witnesses themselves are protected.
Okay.
So you want to tell them also that they are free to, they actually don't have to participate, even though you're paying them for their time. I give you a little tip here that your listeners might be able to use.
Okay.
Remember the name Johnny's Poultry.
Okay.
For real.
All right.
Johnny's Poultry is an old National Labor Relations Board case from about 40, 50 years ago.
Okay.
That basically sets out the standards under the Labor Act investigation for when an employer who has all this authority and power is questioning this employee who doesn't have any power, and therefore it's a one-sided deal. So the labor board said these employees need some protection. So there's some steps you take in which you advise the employee, look, we'd like your cooperation. You will not be retaliated against for participating with us or not participating with us. It's voluntary. You don't have to agree to do this. There will be no retaliation if you don't want to. At any point in the process, if you feel uncomfortable, you can depart, and again, no retaliation. Just look up Johnny's Poultry. That case has been unofficially followed or adopted by many employment agencies around the country. So I think those are good standards to use with employees. So you meet with the employee, you tell them all this stuff, and you get those names, and then you meet with those witnesses.
Okay.
And somebody's going to ask, do you tell them it's confidential?
Yes, that was a question I had for you.
Yeah,
What if they say, what do you say? I don't want to participate. I don't want to be a part of this. What would be the response of the employer with
The
that?
employer should say, if you don't want to participate, that's understandable. We're not going to force you to participate. We would love to have your cooperation on this. It's important. But again, if you choose not to, then we'll end the session now. And there, again, no retaliation for not participating. But
What about this though? If a company has policies that state, one of the expectations in an investigation is for you to participate if you should happen to be asked. If that employee says, I still don't want to be a part of it, the employer cannot force that employee to do it. Is that correct?
should not force the employee. I mean, employers are going to use a little subtle pressure perhaps, but at the end of the day, they can't force the employee to do it. You have to remember the employee in protected group discrimination allegations and harassment allegations. That's for the, race, sex, all the other age and so forth. All of those are protected groups. And when an employee participates in a protected group investigation, the employee is protected.
Okay.
If an employer may bump into a real problem if one of the named witnesses is an employee who the employer was planning on terminating next week for absenteeism or whatever.
Oh, yeah,
and
that would be a problem.
And then they cooperate in the investigation, and a week later they get fired. Well, that was actually the McMillan case out of Nashville.
Oh,
I don't know, 10 years ago or something.
yeah.
And the employer was liable because the jury felt that the employee had been terminated for cooperating in the investigation. So we have to be very careful about that stuff.
Yeah. So,
and that, if I can go one step further,
yes,
that also goes with confidentiality, because employers typically, and this is something when I talk about this stuff, y'all HR professionals don't like to hear me say this. But we always say, now keep this interview confidential.
Yes.
We don't want it spread around or anything. And according to the Labor Board, in many cases, requiring confidentiality violates the Labor Act. And I'm talking about for non-union employers.
Okay.
Because under the Labor Act, employees, regardless of whether the company is unionized, have the right to discuss the terms and conditions of employment. And that includes sexual harassment in the workplace.
Wow.
So when you tell that employee witness, do not talk about this, according to the Labor Board, that probably is a violation of the Labor Act. It's called concerted activity. So the HR folks ask me, well, what do you tell them? I say, well, maybe tell them, now please don't spread rumors.
Yes.
Would that work? I have no idea.
Yeah.
But it's something you could do. I'm not sure it would get you out of trouble if an unfair labor practice charge was filed at the board, but it's better than saying, now keep this confidential.
Just keep this confidential. So HR professionals, that is something that it's been a practice over the years, but we have to be very careful about telling employees to keep these type of investigations confidential. So, all right. We're going to do this. I'm going to give you some what-if scenarios. What ifs, okay? All right, we're in the middle of an investigation, all right? So if the complaining employee quits, or perhaps the accused supervisor quits, should the HR professional still move forward with the investigation?
Absolutely.
You should.
Before employment law came around, in the old days, defense company attorneys would tell the employer, circle the wagons, and if the employee quits, then you can uncircle them because it's over.
Yes.
Well, that ain't happening in our world.
That's not happening
Your
today.
obligation under Title VII and the other statutes is to ferret out discrimination in the workplace,
Mm-hmm.
and harassment in the workplace, and eliminate it. So if the complaining employee quits,
Mm-hmm.
that goal of the statute, the congressional goal, has not changed. It's still find the discrimination and get rid of it.
Get rid of it, yeah.
And so you're still obligated
Yeah.
to do that. And if you stop, you're going to be in trouble, because that person that left is
Mhm.
probably left because they're ticked off,
Mhm.
and they're going to sue you.
Mm-hmm.
And the first thing the plaintiff's attorney is going to ask when they depose the HR professional is, you never completed your investigation of her allegations of harassment and discrimination,
Yeah.
did you? Well, I guess we didn't. You know, he's not going to ask you the second question, why did you stop? It's going to be a technical reason the company stopped, because she quit. But the reality is the employer never followed the congressional intent. So complete your investigation, make it thorough and in good
Yes.
faith. Look under every stone, regardless of whether that individual
Mhm.
has left the company or whether the accused perpetrating supervisor has left the company.
Mm-hmm. And you make a note that that person or complaining employee did quit in the investigation, but you continued on, right?
Exactly.
Right. So there, in these cases, in these investigations, there's always investigators, right? People that conduct the investigation. You may have lead investigators, or you just may have a number of people, right? So broadly speaking, what is the main role or goal of the investigator?
Well, the investigator has to collect all the facts, of course,
Mm-hmm.
and then continue in the process to try and find the source. If there is discrimination, unlawful discrimination based on protected groups, then that investigator needs to find it and get rid of it. And there's just, you know, in today's world, we have highly trained HR professionals like yourself and many others in SHRM and other similar organizations, but especially in SHRM. SHRM Memphis, by the way, a great organization.
Great
that we really
organization.
like. Little sales pitch.
Of course, we have to put it out there,
But
right?
because all these professionals are so well trained by SHRM and others, there's just no excuse for not continuing with a thorough investigation. Let me give you an example of what not to do.
Okay, that's
This
a
would
good
be
one.
on your don't do this list.
Don't do this list.
The employee complains about, let's say, sexual harassment, and the investigator, the HR official, who will probably be the investigator, most likely, says, okay, I'll investigate. Well, the investigation shows there was no discrimination or harassment in this particular case. However, when that employee later sues for sexual harassment, she's going to point out, well, you know, the HR professional at the company, the HR director, borrowed my husband's lawnmower about a year ago, and when he returned it, it had a big dent in it, and you know, they were angry. They almost got in a fist fight. Well, that HR professional should realize that he or she had a built-in bias.
Yeah.
Now, he may not have been biased, but that's not the point. It gives a future plaintiff's attorney something to say, well, the investigator was potentially biased, and therefore the whole investigation is tainted and should be thrown out.
Right.
So
they should, the HR professional, the professional thing to do would be just to remove yourself, right?
yeah, and get someone else.
And get someone else.
And that's a problem, Dr. Lesher, because small companies don't have someone else.
Right.
And it needs to be.
Yeah.
So what do you do if you don't have anyone else? Well, you have a bunch of alternatives. You can get an HR consultant.
Okay.
You can call the SHRM chapter, and they'll tell you some HR consultants.
Mm-hmm.
You have to pay their time, but we got some really terrific ones here in town, so you can get one of them. I would not suggest just someone who's nominally in HR, like in payroll, but has never had training, you know, in real investigation techniques.
Yeah.
But there's some wonderful outside consultants.
Yeah.
Some HR professionals would call their attorney and ask the attorney to investigate. I do not agree with that. I've had my clients call me and ask, and I always try to say, no, you don't want your employment attorney to be your investigator. I've done it once or twice when they insist, but I always try to get an outside consultant. Why? Because here's what happens. You know, the best thing you get when you have an attorney on call, and by the way, every employer should have their employment attorney on speed dial.
On
right?
speed dial. And if you don't have one,
Get-
here's who you call.
Well, that'd be okay too. But basically, you're used to having talks as an HR pro with your employment attorney on anything and everything related to, discrimination, harassment.
Absolutely.
It's a free form because you know that later attorneys and judges can't force you to divulge what you talked about with your attorney in that conversation in most cases, because it's privileged attorney-client privilege.
Yeah.
So you get used to that and you explore ideas, and it's free flowing. That's the whole purpose of the thing, is to allow the clients and the attorney to talk about things that you wouldn't talk about necessarily otherwise, options, strategies, and so forth. You get used to that. And here now you've hired your employment attorney or asked your employment attorney to investigate, and you bring that attorney in, and you're freely talking about the investigation and the results and this and that, all this stuff that you need to talk about strategically, but that you wouldn't really want to ever testify about. You're thinking, well, this is privilege.
Yes.
They can't make me testify. But you remember the first thing I said today in response to your question? The defense to these cases by the companies really is no longer, we didn't do it.
Right.
In certain cases, like sexual harassment. The defense is the investigation.
Yes.
So
Frontline defense.
exactly. So if you've got the attorney doing the investigation, then to use this as your defense, you're going to need to waive the attorney-client privilege and have him testify.
Oh, wow.
And that opens the door to all this stuff that you've been talking about, strategic options, and that you really don't want. You don't want to waive the attorney-client privilege. So that's why I think don't use your employment attorney as the investigator. Get him to advise or consult. Try to retain the privilege. I don't know if that makes sense or if that's.
Oh
one
no,
of those.
that makes perfect sense.
Oh.
And HR professionals, this is a very good tip for them, because that is the first line of contacting someone. Let me call the attorney.
Would it be too problematical if I asked your viewers, to everyone who thought it was a good tip, to send in like $2 to me?
Well, I tell you,
Just a love offer.
Hey, yes, pass the basket, right? Pass the basket. But if you do not have an employment attorney, if you're a smaller company and you don't have one, Jeff Weintraub of Fisher Phillips would be a fantastic one. So just a couple more questions for you. So you're another what if. So you have rumors going around the workplace where women are being mistreated. Race and gender is playing a part. All those things. Can employers conduct a secret investigation when they just hear these things in the air, in the atmosphere? No one's come to report it, but they've heard it.
Well, there ain't no such thing as a secret investigation.
Okay.
There is no off-the-record interviews with employees.
All right.
You can say as an HR professional or as an attorney, now this is off the record, but that's what the employee is going to testify to under oath in court. Because you may feel like, well, sometimes we need to go private or need to go off the record. First, the statutes don't accommodate something like that.
Absolutely.
The purpose of laws like Title VII is not to keep things hidden in the closet.
That's right.
It's to bring
it
into the public light, to make sure to try and prevent employers from engaging in improper activity in the future. The threat of going public, it really helps all of us to not do whatever the bad thing is.
Right.
So there's nothing off the record in these cases, and employers should just really get away from that idea.
Just get away from the idea altogether. Okay. What if an investigator, early in the investigation, feels that the employee victim is telling the truth about a proposed discrimination by the supervisor? What should happen? What should the investigator do?
Well, one thing you can do, and I had this situation many times, and I'm thinking now of a case I had in Texas, 18 or 20 years ago. I remember it was a Sunday. And you know, when you're an HR professional or an employment attorney, there's no weekends off.
That's true. It's telling the truth.
So,
sometimes it's not.
Sometimes it's not. So the HR professional called me that particular Sunday afternoon and said, hey, we've got an employee, a female employee complaining of sexual harassment against one of the top vice presidents of the company.
Oh, wow.
Yeah. And the HR professional said, she's going to sue us because we're pretty sure this guy did this. And by the way, when we had the investigation, he did it all, everything you can think of. He really oppressed this poor woman.
Yeah.
So it was clear to me that whatever happened in the investigation, she was going to file, it's a huge national company, she was going to file a multi-million-dollar lawsuit. So I had to figure out a way to try and reduce the risk. So what I came up with, and this is something that I've tried to follow ever since, is I said, well, you need to commence the investigation. And he says, okay, we'll start it first thing Monday. I said, no, you don't understand. Start today. He said, it's Sunday.
Yeah.
And I said, I know.
Yeah, that's when you found out. Yeah.
Because the key in many of these cases is to do the right thing, to try and find and ferret out the discrimination before the nasty threat letter from the plaintiff's attorney arrives in your mail or hand delivery.
Yes.
Because once you get that letter,
yes,
then everything you do after that is no longer the right thing. You're doing it simply because you're scared of getting sued.
Yes.
And that's what the jury's going to believe one day. So I said, what we got to do here is you guys have to do the right thing before that plaintiff's attorney letter arrives. And I said, I know it's going to arrive in the next couple of days.
Absolutely.
So what they did, they initiated the investigation rapidly. They interviewed witnesses on Sunday afternoon, and on Monday morning, they confronted the vice president on Tuesday, and he chose to neither admit or deny, but he resigned. Okay.
Oh, see.
Now the letter from the attorney arrived Wednesday, the next day. So here's what we did.
Okay.
I asked them the question on Sunday. I said, these allegations of sexual harassment, if they're true, sound pretty severe. And they said, yes, these are severe allegations like exposure and grabbing in a hotel room situation.
Oh, wow.
I said, if it's true, it's bad. And so I said, what if you determine as a result of this investigation that all these allegations are basically materially true?
Oh, yeah.
And the HR professional and the president of the company said, no question, we would terminate. So I said, okay, why don't you make that decision now? And they said, well, what do you mean? We can't decide that now. We haven't investigated yet. I said, I know. I'm not asking you to decide whether you're going to terminate the VP. I'm asking you to decide that if you're going to terminate the VP, if the allegations are materially true.
Yes.
And they said, So that Sunday, they discussed it among themselves, and they decided and documented this, dated it that day, that if, with a big capital I and a big capital F, if the allegations against the VP are materially true, then we're deciding now that he will be terminated.
Yes.
And so a couple of days later, it was determined the allegations were true because the VP didn't deny anything. He chose to resign. The letter from the attorney arrives the next day, and then he and I go into negotiations to try and resolve this potential lawsuit, which he was going to sue for millions of dollars. We met 3 times in the DFW airport in some little conference room, and we settled the case for $10,000.
Wow.
And this was, far below what the company was expecting to have to pay. After we settled it, the plaintiff's attorney told me that, Jeff, he said, I was going for a lot of money in this case. We settled it cheap for one reason only, because you guys had already made the decision to fire this guy if the allegations were true. And he said, I figured that eliminated punitive damages from my potential lawsuit.
Absolutely.
Side note, the resigned VP, the bad guy, was sued individually in Texas by the same attorney. And I don't know what happened. I didn't represent him, but I understand they won millions of dollars, like in the 8-figure range.
Wow.
Company got out for $10,000.
Wow. Are there any new developments or legislation with regard to workplace investigations?
Not so much any new legislation. There's a lot of new legislation on the related, topics that get investigated. But I think what we're finding is that there will be more need for investigations in the future because there's more causes of action. There's lots of new legislation. There are, with the new Pregnant Workers Fairness Act, which just came out.
Yeah.
That makes discrimination on the basis of pregnancy illegal and actionable. So there's going to have to be more investigations as to that topic.
All right.
You can go down the list. There's just the use of AI by employers, artificial intelligence. HR is using a lot of HI.
Yes. Yeah.
And they're using that now in investigations,
Yes.
which is, kind of amazing, but I'm a little nervous about the whole AI thing. Do we really want, robots
Yeah.
deciding? I don't think that's the goal of AI. I think it's just another aid that HR professionals can use.
Not the only thing, but a thing or a method that can be used. Yeah.
I guess you could look at, this isn't really new legislation for investigations, but you'll remember, I don't know, 4 or 5 years ago that Congress decided and passed a law that in non-disclosure agreements would be non-disclosure agreements were going to be disfavored in settlements of sexual harassment cases. So they removed the tax deductibility of any damages paid, any attorney fees, and so forth. But recently, another law was passed which bars or prohibits employers from having pre-dispute releases in settlement or releases of sexual harassment claims. And this whole thing about employers and individuals being outed on social media because they tried to keep someone from talking about that they had sexually harassed, and that's horrible anyway. That someone would try to bribe a female employee into not talking about what the bum did. So Congress did this, so it prevents pre-dispute settlement requirements. Like if an employee goes to work at Acme Steel, I'm making up that name, and the employer says, well, you can work here if you agree in this employment agreement that you will keep confidential any accusations you might make of sexual harassment against the company. Well, that's before there's any dispute. So that would be barred under this law. What's not barred is after an investigation, a settlement that has confidentiality requirements in it. That would not be prohibited under this law, just pre-dispute stuff. So the only problem for an employer with the post-dispute settlements is the tax deductibility is lost for the monies that were paid in the settlement.
Wow, you have learned a lot today on Let's Talk HR with Dr. Deneen. I tell you, so would you say, Jeff, that what you should know about workplace investigations, we've covered almost all of it? What you should know?
Yeah, there literally is nothing else.
We covered it. I made sure of it. We were going to cover all of it. And now we'll take a look at our HR go-getter for February 2023. She is Linda Graffenried. The organization that she works for is the Salvation Army Kroc Center. She's an HR coordinator, been there for 5 years. I asked her the question, why do you love this profession? She stated, I love the day-to-day duties of being an HR professional. HR is always changing in an effort to make things better. I love that I get to help others make a positive impact and continuously learn about HR. And she said this special note, I'd like to thank Dr. Deneen Lester for everything that she has and will teach me as we continue in the HR career. That's Linda Graffenried, HR Go-Getter, February 2023. Wow, If you didn't know the details about workplace internal investigations, now you know what you should know, how to conduct them, and what are the new developments with regard to the topic. You cannot lose as an HR professional or business leader to be well informed and knowledgeable about the steps, processes, and outcomes of workplace internal investigations. Hopefully, this episode helped you to put those things into perspective. Be sure to watch the next episode or new episodes of Let's Talk HR with Dr. Deneen, the first of every month on the YouTube channel of the same name. Please note, you can watch Let's Talk HR with Dr. Deneen and prior episodes at any time. Go to the YouTube channel and type in the talk show title. Be sure to subscribe and click on the notification bell. This is HR TV. I'm Dr. Deneen, and I want to talk HR with you. HR forever. See you next time.